Here in Texas, just as is the case in pretty much every other state in America, before a district attorney can charge a defendant with a felony level offense, they have to first present that case to a grand jury. And then that grand jury, after analyzing all of the facts and the evidence that they have, has to issue a document called an indictment. But what is a grand jury? What specifically is their job? Who makes up a grand jury? How does it work? Those are some of the questions that we're talking about in this week's video. So stick around and let's talk about grand juries. Happy Friday, everybody. Hope you're having a great week and gearing up for another awesome weekend. This week, we're talking about grand juries. Now, grand juries are an interesting subsection of the law. They are something that I, as a defense lawyer, know what I know because I've read about grand juries in the Code of Criminal Procedure. I've talked to prosecutors who present cases to grand juries, but it's not something that I know based on my firsthand knowledge because as a defense lawyer for my entire career and having never prosecuted a case, I don't have the right to observe a grand jury in session. Grand juries are closed sessions. They operate behind closed doors in secrecy. They are not open to the public. They are not open for observation. And they are not something that I, as a defense lawyer, have any right to observe. And so I haven't seen a grand jury operate. But I can tell you basically how they work, what their job entails, and what they're looking for. So first off, a grand jury is similar to a jury in a criminal or civil case in that it consists of citizens of the county who are responding to a jury summons and who go through the voir dire and selection process and who are selected to sit on a grand jury panel. Now, what makes it different than a criminal or a civil jury is that rather than sitting through one case from beginning to end and then making a determination on guilt, innocence, or liability, or money damages, or anything like that, they instead meet most often one time per week for a 3-month period, a quarter. They meet for a quarter, and they meet once per week, and they hear a whole host of cases. They might hear 100 or 150 cases during their term as a grand jury. Now, grand juries consisted of 12 individuals, 12 citizens, but another big difference between a grand jury and a civil or a criminal jury is that unanimity is not required, meaning they don't have to all agree. If a case is presented to them and they want to make the decision that, yes, I believe that case should move forward and that person should be charged with a crime, it doesn't require all 12 members agree. It only requires 9. Likewise, if 9 of the 12 feel that there is not sufficient probable cause and that the case should be what's called no-billed. A no-bill is just another name for the grand jury has found that there is not probable cause to move forward and therefore the case is dismissed or disposed of. If 9 of them feel that way, then the case gets no-billed. It does not require a unanimous decision. Now, the way it typically works, at least based on my understanding, is that when a grand jury is seated, a prosecutor of the county in the district attorney's office presents them with each case in sequence. And they start to say, all right, this is the case of the state of Texas versus John Smith. John Smith is being accused of having committed aggravated assault with a deadly weapon on such and such date. Then the prosecutor will present to the grand jury whatever facts or evidence the prosecutor feels are relevant for the grand jury to make their decision. The prosecutor can call witnesses and typically will call, at the very least, the detective or the law enforcement officer or the arresting officer that witnessed or investigated the crime. And then that detective or that law enforcement officer would present evidence or testimony to the grand jury about what they observed. Now, another key difference, at least in a lot of counties in Texas, is the grand jurors are allowed to ask questions of the witness. So if a witness is testifying and there is a follow-up question that needs asked, or if there is a hole or a gap in the evidence that the grand juries feel that they need to make an appropriate decision, they're allowed to ask a question of that witness and have the witness answer them. Likewise, Grand juries can issue subpoenas if they feel that there are certain documents or certain things that they need to see or certain witnesses that they need to hear from. In some circumstances, they can issue a subpoena, ask the court to issue a subpoena, and have those documents presented to them or have that witness appear and testify before them. They can issue those subpoenas if they feel that it would be relevant and helpful. And the other thing about grand juries that's a little bit different than a criminal or civil grand jury is that this is a one-sided affair. So the person that is presenting the grand jury this information is the prosecutor. The witnesses are typically all called by and questioned by the prosecutor. The defense attorneys have no right to be in the room. In fact, in most instances, we are barred from being in the room. We are not allowed to cross-examine the witnesses. We are not allowed to ask our own questions. There are some counties and some circumstances where the defense lawyer can make a presentation to the grand jurors in written form. So we'll submit what's called a grand jury packet of information that we would like the grand jurors to consider, but we are not present to make sure that they read it. We are not present to make sure that it gets presented to them in due course. I mean, we just have to trust and assume that it is. It is a one-sided situation where really the odds are stacked against the defendant. There is a statement amongst criminal defense lawyers and kind of the criminal justice world in general that if a prosecutor wanted to, it could indict a ham sandwich, meaning the bar that they have to clear to get an indictment is very, very low. They are allowed to present whatever evidence they want. They are under no legal obligation to present all evidence or any mitigating evidence or exculpatory. They just simply say, here's what we think happened. Here's why we think it happened. Here's the evidence that we think shows that happened. And then if the grand jurors agree, then they issue an indictment and the case moves forward. So it's very one-sided, very different from a trial. It is not contested. There's no arguing. There's no debate. It's simply here's what we want. Here's what we're asking you to do. Now, good prosecutors have three options available to them when they're presenting a case to a grand jury. They can ask the grand jury to issue an indictment, which is the typical thing that they do. However, they could also ask the grand jury to issue a no bill. If they think that this is a case that for whatever reason needs to be presented to the grand jury because of the type of offense it is or because of the media exposure to the offense, that needs to go through the proper channels, they're allowed to present that case to the grand jurors and then simply say, but we're not asking that you issue an indictment. We're asking that you no-bill this case because we don't feel that we could prove this case up at trial. We don't feel that we have sufficient evidence to secure a conviction. Therefore, we're asking you to no-bill this case. They could also take no position and they could simply say, here's what the allegations are. Here's what the evidence is that we've uncovered. Here's the evidence that we haven't uncovered. And grand jurors, we will defer to you. Whatever you feel is right, we will support that decision. And then the grand jurors can do whatever they want. Now, of course, the grand jury is not bound by what the district attorney asks of them. They can certainly no-bill a case that the prosecutor wanted an indictment on. They can certainly indict a case that the prosecutor asked for a no-bill on. It's completely up to them. They are an independent body. And in fact, when they are deliberating and discussing what they are going to do, not only is the defense lawyer not allowed in the room, but the prosecutor is not allowed in the room either. The deliberations are completely secret and sealed off, and they are allowed to deliberate independently with nobody else overseeing them. So that's a little bit about how the grand jury system works here in Texas. As always, there are nuances and subtleties to this topic that we could dive deeper into. So if that's something that interests you, if you have a specific question, then please feel free to leave a comment below. That certainly helps the channel out. Please feel free to come by any of my live streams. I typically live stream on Sunday and Wednesday nights over on Twitch. I'm happy to chat with you about this or any other topic that interests you about the law. That's what those places are there for. So, hope you all have a great weekend. I hope this was at least somewhat informational. Until I see you next Friday, everybody out there, be good and stay on the right side of the bars.